Good afternoon, and thank you all for joining us today. I'm Advocate Uri Morad, and I'm the Director of International Law and Public Diplomacy Department at the Jerusalem Institute of Justice. I'm very happy to be here with you today, live from Jerusalem. For those who are joining us today for the first time, I want to quickly recap our two previous sessions. Our first session was dedicated to a discussion regarding the boycott, divestment, and sanctions movement, also known as the BDS movement. We revealed their roots, their true goals and strategies, and examined the constant pressure they put on policymakers, legal tribunals, and intergovernmental organizations, all in order to delegitimize and damage Israel on multiple levels. Our second session was dedicated to the intricate relationship between Israel and the United Nations over the last 70 years. We discussed few of the most controversial resolutions taken by the UN subsidiary bodies and illustrated the bias, hypocrisy, and double standard that characterize the UN's policy with regards to Israel. These sessions are, of course, available online on YouTube. In today's session, I want us to take another step forward so we can understand the mechanism operating behind the scenes and examine how a successful campaign that doesn't involve rockets or Molotov cocktails impose new challenges for Israel through significant political decisions disguised as legal concerns. But before we start, I want to tell you a little bit about the Jerusalem Institute of Justice and our International Law and Public Diplomacy Department. So our department strives to uphold human rights in the Middle East and safeguard the legitimate standing of the State of Israel among the nations. Our department operates both in the international legal arena as well as in the public diplomacy arena, as we see these two arenas as complementary and vital. We are proud to stand at the forefront of the struggle for the just existence of the State of Israel in the family of nations. We see our struggle against the rise of anti-Semitism worldwide, the delegitimization, demonizations, and attempts at isolating the State of Israel as a moral mission. So today's session is full of legal and very technical content, all of which is covered in the PDF booklet you should have received in the invitation to attend this webinar. In our time today, we will examining and analyzing in greater details three important decisions, and we will include a brief discussion regarding Israel's course of action. We will first look at the United Nations' disgraceful attempt to use boycott practices and wage political warfare on Israel through blacklisting companies that are operating legally in the disputed territories. The next point we will cover is the ruling of the European Court of Justice, which states that products from the disputed territories must be labeled. Our third point addresses the International Criminal Court's political determination to hunt and wrongfully investigate Israelis for war crimes. And we will conclude our session of the day with a short discussion regarding Israel's strategies to counter these new challenges. So let's dive right in. On February 12, 2020, after nearly 4 years of BDS efforts, the United Nations Human Rights Council, or the HRC, published a database of 112 companies that conduct businesses in Judea and Samaria, the Golan Heights, and East Jerusalem. Many companies on that list hold contracts or agreements with the Palestinian Authority, and they provide essential utility services to the Palestinians, such as gas, water, and electricity. This database is intended to financially damage Jewish-owned companies and companies that maintain business relations with Israel. Big companies such as Airbnb, Expedia, and TripAdvisor. The HRC has never compiled such a database before, for any business activity in any other conflict zone in the world. This successful campaign was a joint effort of pro-BDS organizations alongside different non-state actors that supports the BDS agenda. For instance, the renowned Amnesty International laid the groundwork for defining the criteria for enlisting companies to the database, and the lobbying efforts were entrusted to the Human Rights Watch. Amnesty International and Human Rights Watch are both well-known anti-Semitic organizations. Over the years, the UN has proven time and time again through a series of resolutions and condemnations that its approach towards Israel is characterized by double standard, bias, and hypocrisy. And the publication of a blacklist was no doubt a black day for the UN. Let's briefly examine what makes this a truly an outrageous step. The HRC's actions are clearly outside its given mandate. The Fundamental Treaty of the United Nations, also known as the UN Charter, explicitly states in its Article 41 that only the Security Council is authorized to impose sanctions on a UN member state. And moreover, companies operating in Judea and Samaria are subject to the laws in place prior to the Israeli control in 1967, the Jordanian Company Law and the orders issued by the Israeli Civil Administration. And therefore, the HRC and the Office of the United Nations High Commissioner for Human Rights have no authority over private businesses and had no explicit authority to take punitive actions and impose sanctions on Israel. HRC is engaged in an act of selective prosecution. The Kohelet Policy Forum, an Israeli nonprofit think tank, published 2 reports examining the economic practices of companies in territories under occupation. The report concluded that every situation of prolonged occupation in the world involves widespread settlement activity, and in each case, business enterprises play a large economic role. The report took a closer look at Western Sahara, Nagorno-Karabakh, Northern Cyprus, and Crimea, analyzing 44 companies operating in these territories. Big companies such as Vodafone, BNP, Turkish Airlines, and Renault. It has never been suggested by the United Nations or by state attorney generals that these leading companies are violating international law by operating in these territories. Let's move to a short legal observation. And let me say it simply. Not only that these actions are clearly outside HRC's given mandate and an act of selective prosecution, but rather the legal basis is completely twisted and fundamentally wrong. International humanitarian law does not prohibit economic activity in disputed territories and does not apply to private corporations. But the legitimacy of private economic activity is getting support from local courts as well. One familiar case is the case of the Washington District Court's dismissal of a lawsuit brought by the family of an anti-Israeli activist named Rachel Corrie. Corrie died in an accident with an IDF bulldozer, which she herself caused, while disrupting an Israeli Defense Forces operation back in March 2003. The plaintiffs in this case argued that Caterpillar Inc., the company who supplied the IDF with the bulldozer, committed war crimes since they knew that the bulldozer would be used for home demolition. The court noted that the Geneva Convention does not apply and it does not create private claim for relief. So to conclude this section, I'll say that the United Nations proves that it's simply unable to withstand the political pressure exerted on it. Particularly worrying in this case is the fact that this is a bureaucratic body comprised of some of the worst regimes in the history of mankind, operating manifestly outside its jurisdiction and in the absence of any legal or moral justification, all in order to terrorize law-abiding corporations and damage Israel's economy. I hope you're still with me as we take a closer look at our second ruling of the day. This time coming from the highest court of the largest democratic parliament in the world, the European Union. Israel and the European Union holds a very complicated relationship. Israel is, of course, not an EU member, but both sides enjoy various fruitful collaborations. Israel, for its part, is making great efforts to strengthen ties with the EU in a wide spectrum of fields. Regarding the Israeli-Palestinian conflict, the EU holds a clear position. It believes in the two-state solution solely, with zero conceptual flexibility. The EU wanted to play a more dominant role in the Israeli-Palestinian peace process, but in light of internal disagreements and prominent American involvement, it was pushed back and forfeited in its position. The EU repeatedly claims that it does not support any forms of boycott or sanctions against Israel. But in fact, the ruling that we are examining today proves otherwise. The court allowed in its ruling the labeling of Israeli products that are manufactured in the disputed territories in all 27 EU countries. This discriminatory ruling was not made in a vacuum. It is a result of an intense pressure exerted on the EU at all levels. Pressure that has been going on for almost a decade. In 2012, 22 major European NGOs published a report named Trading Away Peace, How Europe Helps Sustain Illegal Israeli Settlements. This report calls on the EU, as well as national governments, to wage political warfare on Israel through various forms of economic sanctions. And approximately 3 years later, the European Council for Foreign Relations released a report named EU Differentiation and Israeli Settlements, calling for boycotting Israeli entities that hold financial contracts with Israeli settlements. These publications advance a BDS agenda and call on the EU and national governments to put pressure on Israel through various forms of economic sanctions. And product labeling is their opening step. But applying this kind of pressure requires resources and a widespread mechanism, one that consists of field organizations, research organizations, speakers, consultants, CEOs, and employees. And who pays for this, you wonder? The EU itself. A new report published by the Israeli Ministry of Strategic Affairs reveals that despite various statements by EU officials and contrary to its official policy, during the years 2011 to 2019, EU bodies provided tens of millions of euros to various Palestinian and European organizations. Let's take a closer look at this ruling and the potential damage it can cause. From a non-binding interpretive document to a full-scale catastrophe. Behind this shameful ruling stands the fight of a single victim. The victim in our story is a winery called Psagot, situated in the Benjamin Regional Council. In 2016, Psagot Winery filed a petition in a French court against local product labeling. The French court accepted the winery's position and allowed the winery to label their products as Israeli products. But they postponed the implementation of the decision until a ruling was made by the European Court of Justice. And indeed, the EU Court of Justice published its ruling on November 12, 2019, and stated that all 27 EU states are required to label products from the West Bank, East Jerusalem, and the Golan Heights, and mark them clearly as such. We can fairly say in this case that the struggle of a single winery led to a full-scale implementation of products labeling all across Europe, a full-scale catastrophe. The Israeli Ministry of Foreign Affairs, by the way, recognized the potential damage inherent in filing such a petition, and they tried to persuade Psagot Winery not to file its petition. But as we can see, this attempt failed. Let's move on and talk a little bit about the substantive potential ramifications of this ruling. First, I must say that there has been no significant harm to Israeli exports to Europe thus far, and yet implementing such an extreme step in 27 countries may cause some substantive potential ramifications in the near future. First, this step boosts negative world discourse regarding Israel and simply encourages future steps that seeks to deter companies from deepening ties with Israel. But Israel's main concern in this regard is that it may extend the boycott to include businesses that operate within the Green Line, as well as targeted campaigns calling for countries outside the EU to apply same practices. So to conclude this section, I will say that, like the UN, the EU as well succumbed to the pressure and joined the fight against Israel in a political decision disguised as a legal concern. But what makes this ruling particularly scandalous, shocking, and frightening is the fact that it recalls the practice of labeling for Jews on European soil, exactly like the obligation for Jews to wear yellow badges on the clothing as an identifying mark and an act of humiliation about 80 years ago in Nazi Germany. You're on your way to becoming an expert now in Israel's international relations, and the third and final decision we will examine today is the International Criminal Court's determination to investigate Israeli soldiers and statesmen for committing war crimes. The decision of the chief prosecutor of the International Criminal Court to launch a comprehensive criminal investigation of alleged war crimes committed in what has been named the situation in Palestine is dramatic but not surprising. It was made somewhere back in 2015 when the ICC accepted Palestine's request to join as a member state of the court and offering the Palestinians a new platform to act against Israel. This decision is particularly interesting as it lays on a very shaky foundation, has no legal basis, and it stands in stark contrast to basic rules of decency. Let's analyze this step in greater details. And first, let's meet the ICC. The International Criminal Court, or the ICC in The Hague, was established in 2002 in accordance with a treaty called the Rome Statute. The ICC's goal is to investigate, prosecute, and try individuals accused of committing the most serious crime of concern to the international community as a whole: the crime of genocide, crimes against humanity, war crimes, and the crime of aggression. In 2015, after it ratified the Rome Statute, the state of Palestine became a member state and empowered the ICC to address international crimes committed in its territory after June 13, 2014. Israel is not a member state of the court, and as of today, the court has 123 member states, and it is conducting legal proceedings related to 12 different situations. Let's talk a little bit about the charges to be pursued in this situation in Palestine case. On December 20th, 2019, after 5 years of preliminary examination, the chief prosecutor of the International Criminal Court, Fatou Bensouda, expressed her determination to investigate Israelis for war crimes. According to Chief Prosecutor Bensouda, the investigation would focus on 3 potential charges. 1, alleged crimes committed by IDF soldiers during the 2014 Protective Edge operation. 2, the transfer of civilian population to occupied territories after 2014 and the expanding of the Israeli settlements in the West Bank and in East Jerusalem. And 3, crimes allegedly committed by IDF soldiers during the quote-unquote peaceful March of Return that started back in March 2018. But worth mentioning in this regard is the fact that alongside ICC's determination to investigate Israelis, the ICC also expressed its intentions to investigate Hamas for criminal use of the Palestinian civilian population as human shields, as victims of murder and torture as well. I'm proud to say that JIJ's efforts succeeded to convince the ICC to accept the legal and evidentiary infrastructure we presented to it, calling for the investigation into Hamas's war crimes. The ICC lacks jurisdiction. In the case of the situation in Palestine, the fundamental precondition for jurisdiction enshrined in the Rome Statute, namely that a state having criminal jurisdiction over its territory has delegated such jurisdiction to the court, is clearly not met. And simply put, there is no presently existing state of Palestine that is capable of referring matters to the ICC. And in order to examine whether Palestine meets the conditions for statehood, we turn to the 4 criteria for this set in the Montevideo Convention of 1933. Let's look at them briefly. 1, define territory. As agreed by both Israel and the Palestinian Liberation Organization in the Oslo Accords, the territory will be defined upon negotiations between 2 parties. 2, a permanent population. In the absence of a defined territory, it cannot be stated that a permanent population can be defined. And 3, a government. And let's say it simply. There is no single government in total control of all its claimed territory. As Hamas governs the Gaza Strip, while certain areas of Judea and Samaria are subject to the limited administration of the Fatah-controlled Palestinian Authority. And 4, the capacity to enter into relations with other states. And as a result of the lack of one effective government which controls all the areas in question, the ability to maintain external relations in a uniform voice is impaired. What I want you to remember is that the ICC in its decision completely ignores the fact that Palestine does not meet the 4 criteria set in the Montevideo Convention. ICC's decisions stand in stark contrast to its basic principles. As a court of last resort, the ICC may only exercise jurisdiction where national legal systems fails to do so. In other words, the court can prosecute only where a country is genuinely unwilling or unable to do so. This is a basic principle enshrined in the Rome Statute called the principle of complementarity, as the court's jurisdiction is complementary to state jurisdiction. I will not go into Israel's argument in this stage as it requires a whole different webinar, but what I would say is that Israel proudly holds a self-reliant, independent, and impartial judicial system. Past experience shows that wherever Israel recognizes a potential deviation from the morality and values that characterize the IDF in its activity, it is always willing to conduct necessary investigations and, when needed, to indict. And the Israeli judicial system is definitely meet the requirements of the international community. I have to say it will be very interesting to see how the court will try to circumvent this important principle. Scandal and foregone conclusion. Any legal institution must operate independently and must be entirely impartial. These principles must stand at the core of any legal tribunal. But in contrast to the Israeli independent and impartial judicial system, the ICC holds a very controversial decision-making process. In the case of the situation in Palestine, Chief Prosecutor Bensouda was involved in an alleged collusion together with the Abbas-appointed PA committee handling ICC matters. This committee, by the way, includes 6 representatives from Hamas, as well as the Popular Front for the Liberation of Palestine, 2 designated terror groups. Palestinian Media Watch, an Israeli NGO that serves as a media watchdog group, has reported that the chief prosecutor of the International Criminal Court allegedly secretly colluded with the PA and had already decided to prosecute Israel. In an interview conducted by a Jordanian news site named Jafra, a PA official said that the International Criminal Court prosecutor, Fatou Bensouda, deceived the international community when she initiated a pre-trial request, supposedly to determine whether the ICC has jurisdiction over the situation in Palestine, when the decision is a foregone conclusion. So, to conclude this section, in a sense, the ramifications this ICC decision raises are different than the ones we examined previously. So far, we talked about a campaign that wishes to cause damage on Israel through economic pressure and boycott practices. Now we are looking at a whole new challenge, one that imposes danger both on military personnel and statesmen to face criminal charges. But even though the implications are different, this decision illustrates once again that even international tribunals are under enormous pressure. Pressure they simply cannot bear. So now that we have finished discussing the scandalous decisions of both the United Nations, the European Union, and the International Criminal Court, I want you to take a closer look at the following diagram. This diagram can help you identify the mechanism and its generators. So as you see, the BDS movement applies pressure on both the United Nations and the European Union in order for them to take active steps against Israel. This pressure is effective, and as a result, they act through resolutions and condemnations. This influences the ICC to take legal actions as well and announce its determination to investigate Israelis for war crimes, as the ICC itself relies on the UN's action. So this is what makes the BDS campaign a successful campaign. The developments we have discussed today pose new challenges for Israel, and new strategies are needed to address them. Let's briefly go over the effective strategies to counter these new challenges. And it starts with legal actions, a worldwide legal warfare to address a wide spectrum of challenges. These efforts focuses inter alia on positioning Israel as an influential force in international law, expanding circles of pressure and influence, integrating non-state actors alongside state authorities in the fight against BDS's attempts to harm Israel, and widen the circles of support for the working definition for anti-Semitism in order to halt the alarming rise of manifestations of anti-Semitism. Next is gathering wider international support. Israel is making great efforts to gather as broad worldwide state support as possible. This support aids Israel in its efforts to slowly and deliberately gnaw away at the numbers of countries that automatically vote against Israel at the UN, to halt the ICC's determination to investigate Israel, and allows Israel to work together with European leaders through diplomatic channels in order to prevent the promotion of economic boycotts against Israel throughout Europe. Last but not least is gathering public support. So far, we've talked about the state support. Now we're moving on to gathering public support. Israel is joining forces with civil society organizations in order to balance world discourse regarding Israel, achieve broader support, and strengthen Israel's standing among the international community. Using a variety of tools, Israel's public diplomacy works to utilize Israel's powerful and strong standing, alongside targeted campaigns to mobilize the general public against the BDS movement by revealing the true goals, their lies, and exposing their values, agenda, and strategies. We have covered a lot of materials today, and you're probably wondering now, how can you get more involved? And what can you do? So first, don't forget that you are a valuable part in the fight to fend off these attempts to boycott or damage Israel's economy. So here are a couple of simple things that you can do. First, show zero tolerance of any attempt to implement any kind of discriminatory practices against Israel's economy in your own towns. Next, boycott the boycotters. Show them that you are simply not willing to support companies that boycott Israel. And use your social media presence to stand up with Israel with the truth. We have provided you with a PDF booklet with detailed information on all issues we've discussed today. Please use it to educate yourself and inform others. Thank you so much for joining us today. It was a pleasure to share with you. Please email us with your questions and stay tuned for updates on future lectures. Shalom from Jerusalem.